One of the biggest problems in the payment processing industry is a lack of transparency. This couldn't be more evident than the way contracts are executed. A typical merchant services agreement is 3 to 5 pages long. There's a tiny little clause at the end to the effect of, by signing this agreement, you're agreeing to our terms and services listed here, that links to a URL. The problem? The terms of services document is usually 75 pages or more. On top of that, sometimes you can't see those terms because you're not even an account holder. That's a problem because buried deep inside the terms of service, you'll find the length of the contract, the cancellation fees, and liquidated damages. Basically, everything the company can charge you for early termination. A standard merchant services agreement is a 3-year contract with a $495 cancellation fee. Liquidated damages can be $100 or more for every month left on the contract. So if you're halfway through the contract and find a better deal elsewhere, what you didn't know about the terms of services could really cost you. Let's say you decide to ride out the contract. Most agreements give you a very narrow window, just 30 days, to give written notice that you intend to cancel. Miss the window and the fees reset, holding you hostage for another full term. Maryland House Bill 777 changes all of that. Starting October 1st, the signature page of the Merchant Services Agreement must spell out the length of the agreement, cancellation fees, liquidated damages, and the renewal date. Each item must be listed in 12-point bold font, and each one must be initialed by the merchant. And that's not all. Combined fees for terminating an agreement cannot exceed $500. Your merchant services provider is also required to notify you at least 60 days prior to renewal. If the agreement does automatically renew, then they're prohibited from charging any type of fee, fine, or penalty should you decide to terminate their service. The law applies to all MSPs doing business in Maryland. Only providers who use month-to-month agreements and do not charge cancellation fees, penalties, and/or liquidated damages upon termination of their agreements are exempt. The law applies to businesses with fewer than 50 employees and that process less than $2 million per year in credit card sales. Once it takes effect, Maryland businesses will no longer be penalized by unfair merchant services contracts or forced to tolerate poor customer service for an extended period. For more information on House Bill 777, please visit marylandhb777.com.